In the U.S., we have a trial by jury. Not all countries have this. We also have trials to the court. The difference is when it is a trial to the court, that means it is a trial just to a judge, and in that situation, the judge is the fact finder and the arbiter of law. In other words, the judge determines what facts are accepted as true and applies the law on that particular case to those facts to make a decision. When there is a jury, there is still a judge, but the fact-finding assignment now goes to the jury, and the judge retains the legal decision-making authority. The jury speaks in the final verdict, and not before then. The judge speaks all the time. The judge rules, is the traffic cop through the court to determine procedure and to make sure that procedure is followed. Each separate court has its own rules on procedure. Then the judge also makes evidentiary rules, which is not procedure. The way they're argued or brought is procedural, but the substance is what now the judge is determining. When there are objections, the judge makes a legal determination on what should or shouldn't be allowed as evidence. Likewise, motions can be brought during the trial, and the judge will rule on those on the law. And then finally, the jury verdict can be thrown out by the court if the court finds, the court being the judge, finds that there's no way that the jury could have found the way it did based upon the evidence presented. And that's called a judgment notwithstanding the verdict. So that's the basic part. Now, as a litigant, a person in a civil case where you're suing someone or you're being sued, you don't always get a right to a jury, and that's because you might have a contract that waives the right to a jury trial. This is traditionally so in situations where you have a contract to borrow money, you have an employment contract. Many business type situations, there will be a jury trial waiver. People, attorneys, and then parties also like to have those in the documents because it saves money. A jury trial is much more expensive to the parties than a trial to the court because there's more preparation time that the attorneys have to do in advance to satisfy the rules of that court when a jury is being called. I did another video on when you serve as a jury, and I go through some of those scenarios in that video, so you see that there's extra work involved. Also, because there is a jury involved in a case, the trial is much longer. It's much longer because when there are evidentiary matters before the court outside of just admission of evidence, the jury will be excluded. And that's because the court has to make a record of everything. And when you see the court reporter taking down everything, that is the official record of the case, and everything needs to be recorded. And they can't have the jury hear some of these arguments because it can affect what's going to happen. But the attorneys are making their arguments so that they're preserved for the record. So shuffling the jury in and out of the room, dealing with 12 to 15 or more people extra. They have to all park their car in the morning. They have to go out for lunch. They have to come back for lunch. They have to have a coffee break. And it just adds time to the trial, and it adds expense. Now, in a criminal situation, the only time you see a jury waived is when a plea is being made and somebody's they've agreed to some type of plea arrangement and there's not going to be a trial. Very, very seldom would you have a criminal matter that is not tried to a jury. And that's a fundamental issue about people's freedom and their liberty. In a civil matter, it's not about somebody's personal freedom. It's about money or having to do something in equity. So that's the reason for that. You have a right to a jury in both state and federal court. The procedure for that is fairly the same. Now, in state court, when you are suing somebody, some places it's automatically part of it if it's not waived in the documents that are involved in the suit, and sometimes you have to affirmatively ask for it within a particular period of time. So that is something, if you are going to be a litigant in a case, if you are being sued and the plaintiff has to ask for a jury and they didn't in the papers, you as a defendant have the right now to assert your right to a jury trial. If there is one automatically provided for by the local court rules, then there's a certain period of time in the case when the parties might consider waiving it. Even though there was not a document ahead of time, they can waive it to proceed going forward at that period of time. And the jury is going to be different sizes depending upon the different kind of case and the court that it's in. Usually it's 12, but there are situations where you can have it reduced, and sometimes that's by rule and sometimes that is by agreement. So it is a right that you have unless it is waived, and it's a valuable one, and I hope that helps you understand.